Hello everybody, this is Aishley Verma, an intern with LEXIS and Company, and today I will be dealing with a case that is decided by the Supreme Court of India. So the title of the case is, just a second, Avitel Postal Studios Limited and others versus HSBC PI Holding Mauritius Limited. Citation of the case is 2020 SCC online, Supreme Court 656, and the case number is Civil Appeal number 5145 and 5158 of 2016. So date of judgment is 19th August 2020. So the bench consists of Justice R.F. Nariman and Justice Naveen Sinha. So the facts include HSBC entered into an agreement with Avitel to acquire Avitel's share, amount rupees 60 million USDs. Further, the investment was based upon Avitel's warranty and representation that it was at an advanced stage of finalizing a contract with the British Broadcasting Corporation (BBC), which had the potential to generate revenue up to 1 billion USD in future. And this all happened in 2011. Further, HSBC got a suspicion of Avitel's business and plan, and hence appointed two investigating agencies to inquire into the business activities of Avitel. Later on, the discovery of the investigating agency in 2012 indicated the appropriate BBC contract was not in existence, and it was only a trick to induce HSBC to make the investment. In 2012, HSBC sent a notice of arbitration to the Singapore International Arbitration Center and sought urgent relief in the emergency arbitration proceeding. An emergency arbitrator passed two interim awards in favor of HSBC, directing Avitel to refrain from disposing and diminishing its asset less than USD 50 million. Further, in 2012 only, HSBC filed a petition under Section 9 of Arbitration Act 1996 before the single bench of Bombay High Court, seeking interim relief for direction to call upon Avitel to deposit a security amount worth rupees 60 million USD to secure the dispute amount in arbitration. As such, the court passed an interim order, which was called Order Number 1, in the favor of HSBC, directing to freeze Avitel's bank accounts. Further, in the same year, 2012, Avitel also challenged the jurisdiction of Singapore International Arbitration Center's three members arbitral tribunal, and arbitral tribunal was pleased to pass an anonymous final partial award on jurisdiction, dismissing the Avitel's jurisdiction challenge. Further, in 2013, meanwhile, HSBC filed a criminal complaint against Avitel with the Economic Offence Wing EOW, Mumbai. A closure report in this respect was filed before the magistrate in Mumbai. Dissatisfied, HSBC filed a protest petition against the closure report, which was dismissed by the magistrate. HSBC's challenge against the said dismissal is still pending before the Bombay High Court. Further, in 2014, the single judge bench of Bombay High Court, with the observation that HSBC has the good chance of success in the final arbitration proceeding, passed an order, which was called Order Number 2, in furtherance of Order Number 1, and directed Avitel to deposit any shortfall amount from 60 million USD. Further, in 2014, aggrieved, that was Avitel, preferred an appeal under Section 37 of, again, Arbitration Act 1996 against the Order Number 2 before the division bench of Bombay High Court. The division bench passed an order, which was called Order Number 3, holding that since Singapore law governs the arbitration agreement, the question of arbitration should be decided with reference to Singapore law, and refused to interfere with the findings of single judge. However, the court reconsidered the actual damage to which HSBC may be entitled, and eased the deposit to be made by Avitel, that is 60 million to 30 million USDs. Finally, the SIAC, Singapore International Arbitration Tribunal, rendered the final award in favor of HSBC and held that Avitel is guilty of fraudulent misrepresentation and legally responsible to indemnify HSBC on account of fraud played to the amount of 60 million USD along with interest. In 2015, the aggrieved party by the final award, that is Avitel, challenged the same before the Bombay High Court under Section 34 of Arbitration Act 1996. However, the court dismissed the petition as not maintainable. Avitel's appeal under Section 37 of the same Act 1996 against this order was also rejected. In 2015, to enforce the final order, HSBC moved to Bombay High Court in accordance with the Section 48 of Arbitration Act 1996, and such enforcement proceedings are still pending. In 2017, the Honorable Supreme Court finally heard the appeal and cross appeals filed by the parties against Order Number 3, passed by the Division Bench of Bombay High Court. So the issue involves, according to Supreme Court, the issue which is involved in the case is only the question that needs to be addressed in Section 9 proceedings, in the extent to which HSBC could be said to have a strong prima facie case in the enforcement proceeding and under Section 48, which are still pending before the Bombay High Court. So, if so, whether irreparable prejudice would have caused to HSBC if protective orders were not issued in the favor, and generally whether the balance of convenience tilts in the favor of any of the two extent. So further judgment of the Supreme Court was the Honorable Court accepting the contention of Avitel held that the prima facie case in the present matter would necessarily depend upon what is substantive law in India, and when allegation of fraud was raised by one of the party to the arbitration agreement, the court then proceeded to analyze all the relevant judicial precedents on the issue of arbitrarity of fraud. So referring to one of the case, that is Fazil, Dr. Alana and Mangal Das M versus. So this was the case only. Yes, the case was Fazil D. Alana versus Mangal Das M. Pakwasana. So the court explained the fraud that can be of two types. So contract is obtained by fraud, that is formation issues, and the performance of the contract, which is perfectly valid. So if there is any formation issues, that will not be valid, and then if there is any performance which is at fraud, so that contract will be invalid. So this was all held by Supreme Court of India, and the case is still pending. So that is it. Thank you so much.